Welcome to our continuing series of virtual voices, focusing on the United Nations Sustainable Development Goals and hosted by World Information Transfer. We are very pleased to have with us today Mr. Igor Shpiniov, who is the former Chief of Office of the Under Secretary General for the United Nations General Assembly and Conference Management. Mr. Spino started his career at the United Nations as a translator and moved on to the position of the former Chief of Office of the Undersecretary General. Over to you, Mr. Spino.
Thank you very much, Dr. Durbak. It's a pleasure to be with you and your students and colleagues, as always. First, allow me to congratulate you on the excellent work that you are doing, on the continuation of a very useful series of conferences that you have organized and you are maintaining, which is extremely important in the difficult times that we all are living through. So my personal thanks and congratulations to you, and I'm happy to contribute a little bit today with a topic that may not be very much connected to the kind of mainstream thread environment, but it's still, as you will see from what I will say, it is still, in the end, everything is connected in this world, and the topic of sanctions also has an impact on the issues of the environment and the health of the environment that remains one of the planetary problems, as you know, despite all the political turmoil and the war and the more kind of to the acute crisis of today, but still the main planetary crisis. Some people call it, some experts call it a triple planetary crisis. That remains a priority for the humanity. But I will not dwell much on that. Thanks, Dr. Durbak, for the introduction. I think I will kind of break a tradition of talking about myself in your seminars, but rather use the time to talk about the substantive issues that I wanted to share with the students and you. Those of you who are following the UN documentation, and it's very easy to do that by subscribing to the UN journal. And in the UN journal, which you would start receiving every day once you subscribe, and it's free of charge, of course, there will be a page at the end that would contain a link, subscribe to documentation. So what you can do, you can subscribe to the topics that you are following and be sure that you are not missing anything. So for those of you who are already are following the UN documentation, you would notice that this month is a month when the most important documents for the next session are being issued by the UN in all 6 official languages. This is called parliamentary documentation. These are the reports, various reports of the Secretary General, but also of other mandate holders that have been requested by the previous session or sessions of the General Assembly, and therefore they have been prepared by the structures who were entrusted to prepare them, and now they are being issued before the session so that all those who will participate in the consideration of the agenda of the General Assembly session will have enough time to read, digest, discuss with their capitals, discuss among fellow diplomats, those documents and prepare their negotiating positions for the session. Among those documents, you would notice that there is quite a number of reports of the so-called special rapporteurs on various issues, various matters. So I don't know how much familiar you are, colleagues and students, with this specific mandate. Everybody knows who the Secretary General is and what the Secretariat is, but special rapporteur, as well as special representative, special experts, are very specific mandates that may not be as widely known and as clearly understood as the other mandates. So I will talk a little bit about that. What is that? So everything starts, the process of formulating a mandate and selecting a special rapporteur or a special representative starts with a resolution, normally by the General Assembly, but also sometimes other charter or even non-charter bodies, such as, for instance, the Human Rights Council in Geneva, which formulates a mandate, which formulates a task. For instance, 3 years ago, the Human Rights Council discussed for many days a matter of sanctions. And that is very much connected with the war in Ukraine. Because if you remember, when the war started, one of the first reactions of the international community was to sanction the aggressor state, Russian Federation. And first attempts were made within the UN by adopting the collective sanctions, the United Nations sanctions. But those attempts, as you probably would understand, of course, were met with the resistance of one of the members of the Security Council, the Russian Federation, which has a veto right over any decision of the Security Council, which has to approve UN sanctions. So that led to debates, and very soon it was understood that that path is not realistic, that because of the uniqueness of the situation where a member of the Security Council with a mandate to protect international peace and security becomes an aggressor state and thereby a violator of the Charter of the United Nations, this unique situation leads to a deadlock in the Security Council, where the international community cannot enact any decision that would be perceived by the aggressor state as a decision that is detrimental to its interests. So that process had to stop. And the international community then had to resort to another type of sanctions. So if you are following my logic of my presentation, you would already notice that I spoke already about the first type of sanctions, which is a collective sanctions that are sanctions, but that's how it is called. Sorry, it's not my invention. Sanctioned by the Security Council, in other words, authorized by the Security Council. So that's the most powerful type of sanctions in the world. And that may include sanctions related to any breach of international law, be it international peace and security, or, and here I'm kind of curving a ball to Dr. Durbak, also environmental law. So for breaches of environmental law, there is also a precedent in the United Nations of putting together and adopting sanctions that would punish the perpetrators of the of the breaches of international law related to the environmental regulations. But then going back to what happened in this case with the sanctions, and I'll then segue to the special rapporteur topic. So, since sanctions could not be authorized by the Security Council, but still there is a consensus in the international community, almost a consensus, of the need to use sanctions in order to limit the ability of the aggressor state, Russian Federation, to continue its aggression, to limit this aggressive state's resources, and otherwise demotivate it to continue the internationally wrongful action of war. There was no other way for the states but to resort to the so-called unilateral sanctions. So unilateral sanctions are basically coercive measures which are legal under the international law, but I will talk about that later. There are two schools of thought. Sorry, I'm taking this back. So the unilateral sanctions are the measures, coercive, hostile measures that are taken by one state or a group of states or an organization, but not a universal organization. Here's the difference. So there are United Nations sanctions that are authorized by the Security Council. These are universally recognized. No one is not recognizing them. But there is also another type of sanctions, which is a unilateral sanctions that cannot be authorized by the Security Council for political reasons. But still, they are applied by states as a measure of their foreign policy, as an instrument for them to defend their national interests and security. These are, under one school of thought, these are considered kind of like quasi-legal measures. They are not fully legal because that school of thought kind of states that only the universal sanctions are legal, and everything that is adopted by individual member states may be challenged in the courts. Okay, so I gave you the overall picture of the sanctions situation. So 3 years ago, this debate took place in the UN, and it spilled out into the Human Rights Council, which has a mandate to appoint special rapporteurs or special experts or special representatives to deal with specific matters. So within the Human Rights Council, it was decided to create a new mandate, a mandate of special rapporteur on the negative impact of unilateral coercive measures on the enjoyment of human rights. Okay? Negative impact of unilateral coercive measures on the enjoyment of human rights. I will need to decipher this for you a little bit. Let's dissect this. So this formulation implies that unilateral sanctions have a negative impact on human rights. So this already is something that is very debatable. However, the kind of Western coalition in the Human Rights Council found itself to be in a minority situation when this mandate was discussed. And the Russian Federation and its friends in the global south prevailed, and this mandate was adopted. So the mandate itself, the formulation of the mandate, implies that unilateral sanctions is something that is kind of illegal. It's a coercive measure on the enjoyment of, it has an impact on the enjoyment of human rights. So maybe to go back a little bit, just to make sure that everybody understands what sanctions I'm talking about. I'm talking about sanctions that you read in the newspapers every day. Like, for instance, there is a prohibition for any business or governmental or non-governmental entity or individual or person in the United States, for instance, to have business with any governmental, non-governmental, private, and so on entity in the Russian Federation. That's a very general type of sanctions, except for certain exclusions that were adopted by the Congress in order to ensure just that the world oil prices do not collapse, and there will be a huge impact on the electoral situation here with the huge lines in front of the gas stations and so on and so forth. So with certain exceptions, this is an overall sanction prohibiting business with the aggressive state. There are other types of sanctions in the banking sector, for instance, prohibiting any financial transactions with the Russian Federation banks, prohibiting even payments, like if someone provides a service for me in the Russian Federation, I cannot pay by a bank transfer. In fact, I cannot pay in any way because it is prohibited now by the sanctions. So the sanctions have been adopted by the United States, and similar sanctions have been adopted by the European Union and a number of other states that constitute the coalition of Ukraine supporters in this situation. So these are the sanctions we are talking about. And these are the sanctions that have been questioned by the United Nations Human Rights Council as having a negative impact on unilateral coercive measures on the enjoyment of human rights. So this report is due this week. I really would recommend that if you're interested in the international politics, that you take time to find it. I can even give you the symbol. It's A79 183. It's either already issued today or yesterday, or is in the pipeline and will be issued very soon, this week probably. So who is the special rapporteur, and how the special rapporteurs are appointed? So once the mandate is approved, member states of the United Nations receive a communication from the Secretariat inviting them to submit nominations for the mandate holder position. What it means is that in this case, once the Human Rights Council approved that it wants some eminent expert to look into the impact of unilateral sanctions from the perspective of the human rights, to see if those sanctions affect human rights and what are the kind of contradictions between the sanctions and the human rights. So they sent a message to all permanent missions at the United Nations, inviting them to submit their nominations. They did that. So there were candidates, 10 or 12 candidates submitted by the member states for this position. Then the Human Rights Council held an election. And as a result of that election, legal expert from Belarus by the name Olena Dovhany has been nominated and then elected to become the special rapporteur on the negative impact of unilateral coercive measures on the enjoyment of human rights. So the report that I am looking at, that I recommend you to also look into, A79-183, has been prepared by this person, by Professor Olena Dovhany. It is issued, it's being issued in 6 official languages. You can read it in English, in Russian, in French, in Spanish, in Arabic, or Mandarin Chinese, if any of you speak that. And you will see in that report her analysis of whether or not there is an impact, a negative impact of sanctions on the enjoyment of human rights. So I don't think you need to be a professor yourself to very quickly understand that an expert from Belarus, who is a closest ally of the Russian Federation in this illegal and aggressive war that it wages against Ukraine. Of course, this person would present a picture that would be to the liking of the Russian Federation. So read that report. It is very interesting. It basically tries to prove that any kind of unilateral sanctions are illegal under the international law and should be immediately cancelled. That's the conclusion in one sentence. So what will happen next? Well, next step, I should say that this whole mandate and the report itself are extremely controversial. If you Google it, you will see there is already a debate going on. The report has already been, I think, introduced by the special rapporteur in Geneva. There are journalists from the Russian Federation, from the United States, from Switzerland, interviewing her, and also other experts on this matter. So the debate is already going on. It's a very crucial debate, because it's very important for the civilized world, for the rule-based, international coalition, to know that the sanctions, that the unilateral sanctions that they're using against the aggressor state are fully legal, are fully in line with the international law, despite the opinion that has been expressed in the report of the special rapporteur. So that's what I wanted to share with you. It's a very interesting and hot topic. I think you will hear a lot and read a lot in the mass media in the coming weeks and months about that. And that will culminate, of course, in the General Assembly, where this report of the Special Rapporteur will be debated formally under an agenda item number 71B, which states promotion and protection of human rights questions, including alternative approaches for improving the effective enjoyment of human rights and fundamental freedoms. So there is a special agenda items on the agenda of the General Assembly, 71B, under which this report will be debated. What does it mean, debate? It means that someone, most probably the special rapporteur herself, or her representative, or maybe a representative of the Secretary General, will present the report, which would have been read, of course, in advance by the member states delegates, and there will be a debate then. There will be, the floor will be open for the delegations to express their opinions. And that's where the fight will happen. The big fight about whether or not the unilateral sanctions are illegal or an illegal tool of international policy that is used by member states, legally or illegally. At the end, the General Assembly is supposed to take action. What does it mean, take action? Basically, it's to take a decision on this report, to say that do they agree, do they not agree? So there may be a voting, and as a result of that vote, the General Assembly is supposed to pronounce itself. However, the reality is that if neither of the sides feel that this is kind of an issue that is worth a big fight at this stage, at this time, strategically, they may agree to a neutral wording, such as the General Assembly takes note of the report and requests the special rapporteur to continue or not to continue her research and report to the General Assembly through the Human Rights Council on the same matter at the next session of the General Assembly. So basically, putting it on the back burner. But I don't know what will happen this time. I have a feeling that there will be a fight, there will be a debate, and the issue will be resolved either way, this or that way. Let's see. But this is my little bit of a spoiler for you, for those of you who would be following the GA. Look at this agenda item, follow it. It is very entertaining, I would say, like a thriller movie that is approaching its kind of the highest point, the denouement, as they say in French. So it would be interesting to see. In addition to this, I talked about the sanctions, but there are also other special rapporteurs, and this is the time of the year when their reports are being published. For instance, I'm now looking at a report overview of the implementation of the right to a clean, healthy, and sustainable environment. Document A79 to 170. A/79 to 170. This is also a report by the Special Rapporteur on the issue of human rights obligations relating to the enjoyment of a safe, clean, healthy, and sustainable environment. So this is an overview of how the recognized right to a clean, healthy, and sustainable environment is being actually implemented in practice in our life. Very interesting report. I'm actually working on it now. It is on my desk. The bottom line is, again, a spoiler, that we are very far from ensuring the enjoyment of these rights, but it contains a wealth of very specific and amusing, even sometimes, information about what's happening at the regional level, at the national level, at the level of the United Nations. What are the different interpretations of this right? What are the fights, basically? What are the contradictions? What are the schools of thought? So, for those of you who are specialized or interested in either legal matters, in law, international law, or more specifically in the environmental law, or alternatively, just in the environmental action in protecting the global environment, this is a report that I would also suggest that you follow. Will be discussed also under item 71B of the agenda, through the prism of protection of human rights. Dr. Durbak, I think I will stop here.
Okay.
Over to you. I'm available still to answer any questions or take any remarks.
Thank you very, very much for a very important, particularly at this time, presentation. I'm sure that all our interns and audience are very appreciative of your presentation. I will move on to questions. First question is, what legal challenges do countries face when enforcing sanctions, especially against powerful states?
Okay, so there are two types of countermeasures that are normally used in such situations. One is counter sanctions and countermeasures, and that is widely used. And you can observe that, for instance, the Russian Federation, in response to the sanctions that were imposed against it, unilateral sanctions, also adopted sanctions which at some quarters kind of elicited a lot of laughs and sardonic remarks. For instance, those sanctions. One of them was forbidding certain officials of the United States, like I don't know, including president or vice president and so on, to visit Russia. So I mean, what is the impact of that sanctions? It's purely symbolic, of course. I mean, of course, it is not a real sanction, but there are also kind of more real sanctions. They are also sanctioning certain industries from having business with the Russian Federation, participating in, for instance, natural resource extraction and mineral extraction and so on, in the lucrative activities. So that's one type of response, is counter sanctions. The other type of response is challenging in courts. It is also extremely popular, and that's what individuals do. For instance, the Russian oligarchs, such as Abramovich, Friedman, Aben, some others, they were sanctioned because of their proximity to President of the Russian Federation, who is himself subject to a verdict of the International Criminal Court, as you know, is considered by international law, by the International Criminal Court, as a person that is accused in committing a war crime. But anyway, so these people, the oligarchs, responded to those sanctions by challenging them in the mostly British courts. They are basically filing complaints against the states that are sanctioning them, trying to prove in some cases that, they have nothing to do with the president. They're just business people that are doing business, and anyone who is doing business at that level is supposed to have some kind of connection with the Russian government. So that's their line of defense normally. So they're trying to basically overturn the sanctions through court orders. To my knowledge, some of them succeeded in some minor courts. None of them succeeded in the British courts, to my knowledge, so far, but most of the litigations are still ongoing. However, the Russian oligarchs also found, as always, a loophole, and they are going to other jurisdictions, such as Singapore, for instance, and Thailand. And they're challenging the decisions of the United States, for instance, in a Thai court or in Singaporean court, and which in their mind would be more kind of friendly to their argumentation. So that's another way of doing that. So basically, to answer the question, to summarize, there are two types of response: counter actions or legal challenges through the established court system. Over to you.
All right. The next question is, How do international sanctions impact humanitarian efforts in the sanctioned countries?
Yes, that's a very good question. The first one was also a very good question. So that's why I would urge you to read the report that I quoted. That's the content of the report. The reporter has put into the report a lot of actual information that is real, describing the impact of sanctions on humanitarian situations in the world, in some parts of the world, but also making a lot of claims that I personally find very unsubstantiated. But in short, to answer you, there is an impact, unfortunately, because, for instance, if you look at Venezuela, which is subject to a lot of sanctions from the United States, but also some sanctions from the European Union. The situation is that they, in addition to impacting the targets of the sanctions that are the government of the Venezuela, they are also unfortunately impacting also the rank and file citizens, the general population, and some argue that they affect inequitably the most vulnerable segments of the population, such as indigenous people, such as there is a case made that it is disproportionately impacts children and women, and so on and so forth. Minorities, gender minorities, LGBT plus, because they are already kind of living with a lot of restrictions that are due to structural and systemic inequalities that exist in societies. So there is a cumulative effect of the sanctions in addition to the existing inequalities and sufferings that they experience. So the answer is yes. Unfortunately, there is an impact on humanitarian activities. The sanctions make it even more difficult to certain groups of population to receive humanitarian assistance. However, the situation is repairable. Actually, what is going on now, in many reports that I read recently on this subject, a case is made that these impacts on humanitarian assistance are challengeable through courts. So in other words, representatives of civil society and even government representatives can go to the courts of the sanctioning countries and challenge and explain there that there is an impact on this and that group that is disproportionate and is not in line with the initial purpose of the sanction. That's a very important thing. And the burden of proof to prove that the sanctions affect humanitarian needs will not be on the humanitarian organizations. That's very important. That will be, the courts will ask the governments to prove otherwise, that their sanctions are not affecting negatively the vulnerable population groups, to provide legal evidence to that end. That's very important. So a short answer is yes, there is an impact, but there is also a legal remedy, potential legal remedy for this impact. Over to you.
Thank you. Next question is, what kind of sanctions cannot be applied to the aggressor countries?
well, it's not a matter of can be applied. It's not a matter of legal possibility. Any sanctions can be applied to any countries. If we are talking about multilateral sanctions, okay. So in our heads, let's divide these two types of sanctions: multilateral and unilateral. So if we are talking about multilateral, that's the UN. UN Security Council has to rubber stamp them, has to authorize them. Aggressor state Russian Federation is a member of the Security Council. Therefore, whenever there is a request to consider sanction against the Russian Federation, what does it do? It uses its veto power according to the Charter of the United Nations. So it's a non-starter, right? So it's not a matter of what kind of sanctions you can apply. It's just a matter of procedure. It's a matter of the Charter of the United Nations. It's the result of the fact that the United Nations has been created after the Second World War and was structured by the winners in the Second World War to protect their interest against everybody else. And that's how it still exists in the world. It was not changed. So in order to be able to apply any kinds of multilateral sanctions against any aggressive state, whether or not this member state is on the Security Council or not, what is needed? And a reform of the United Nations is needed. The basic premise of the veto right and the membership of this in the Security Council has to be reviewed and changed. So that's how it works. As far as the unilateral sanctions are concerned, there is nothing at this moment that can prevent any member state from sanctioning another member state. It's a matter of a foreign policy of any member state that is a sovereign area. Foreign policy of a member state is part of its sovereignty. So no one can forbid a member state to apply sanctions against another member state as it sees fit. However, this member state has to be aware that it can become target of the counter sanctions or legal challenges.
Next question. How effective have the international sanctions been in achieving their intended political or economic outcomes?
Partially. The current sanctions regime. Oh, okay. I'll go back. Historically, sanctions were extremely helpful and effective. I will give you a couple of examples. Sanctions against apartheid, which were multilateral sanctions authorized by the Security Council. Those sanctions led to basically to the dismantlement of the apartheid regime in South Africa. So, but those were sanctions that were approved by the General Assembly and then authorized by the Security Council, and they were complied with. They were enforced. That's very important. So the sanctions may be very good, but unless they are practically enforced effectively, they will not be effective. Why were they effective against the South Africa, and why they are not that effective against the Russian Federation? A very simple reason, two reasons basically. One is that the whole United Nations was condemning the apartheid regime, and there was no or very few member states who would allow their businesses or their physical or legal persons that are subject to their jurisdiction to circumvent the sanctions against South Africa. There was an international consensus against it. In case of the Russian Federation, as you see, there is no international consensus, surprisingly. Although at the beginning of the war, there were a number of resolutions adopted at an almost consensual basis, condemning the Russian Federation, demanding the restoration of sovereignty and territorial integrity of Ukraine, stop the war, and so on and so forth. With time, this consensus was eroded, thanks to the very effective diplomacy of the Russian Federation, which is using every trick in the world to impose, their influence, sometimes undue influence on other member states. And the UN is working on the principle of one vote, one member state. So a small African member state, that has some kind of special relation with Russia for whatever reason, sometimes reasons of corruption, has the same weight in the United Nations, basically in the General Assembly, as a huge developed country. So that strategy of eroding the consensus, it partially worked, and that's one reason why the sanctions are not as effective as they were. The other reason is that the world has changed very much. The world has become much more globalized, and the international trade expanded, exponentially since the times of the apartheid. So there are so many ways to circumvene, to go around sanctions. There are so many third parties, fourth parties, fifth parties. There are so many new banks, new jurisdictions, new ways of basically doing business. There is international commerce, colleagues. There was no such. I'm sorry. There is an internet commerce now. You can do business online from anywhere in the world, which did not exist at that time. That's a major factor. So basically, you can abuse the globalization in order to circumvene the sanctions against the member state. That's why. Is it possible to make the sanctions more effective? Yes, it is. And actually, I saw that proposal in a peace plan that was presented by former Secretary of State Pompeo. I think it was presented to the Republican Convention or in connection with the Republican Convention, but I looked at it, and that's one of the things that I really liked there, is the acknowledgement that the current sanctions regime is ineffective, and a proposal to use other mechanisms to make it more effective. Is it possible? Yes, it is. If there is a political will, I believe that it is still possible to make these sanctions much more effective by way of, putting resources into the law enforcement system so that it is capable, has a capacity to track the transactions that are being made through third, fourth, fifth parties, to catch the circumveners of the sanctions by hand, at hand, So that is possible, and that's, I think, what will be coming. Almost the only way of making sure that Ukraine wins in this war. And you hear from both sides, from both Democratic and Republican parties, a commitment to this, that Russia should not be allowed to win. And now President Biden said the day before yesterday at the Democratic Convention, Ukraine should win in this war. So if there is this commitment, there should be a consequence of that. There should be a tightening of the sanctions regime and ensuring compliance. Over to you.
Next question. What are the legal challenges to countries that face enforcing sanctions, especially against powerful states?
Yeah, again, same type of situation. They face a possibility of counter sanctions, even if they are not sanctioning states, but even if they are just participating in enforcing sanctions, they can become target of counter sanctions. That's one challenge. The other one is, of course, legal challenges in the courts. there is also a third type. It's like kind of a soft response, which is also intimidating to some. Just to blacklist, that a fear of apprehension of participating in the enforcement activities because of the fear of reprisals in the form of blacklisting. What I mean, for instance, I am, a business in the United States, AT&T, and I decide that I will not do business in Russia. In response, Russian Federation can, work diplomatically, using its due and undue influence over, let's say, its client states, and as a result of that, AT&T would lose business in other member states.
Thank you. Next question. Can you provide examples of when sanctions have been applied successfully under international law?
I just did the South African example. I just did. By the way, the example of South Africa is extremely important for Ukraine now, from another perspective, not just economic sanctions. It is often debated why the Russian Federation cannot be thrown out of the Security Council, or, or deprived of the right to vote in the General Assembly, thrown out of the General Assembly, and so on and so forth. So to do that, you would need to change a charter of the United Nations. But there is another way that gives this possibility, and the South African example, the precedent of how the international community dealt with South Africa, is very instructive in this respect. What happened then was that, due to the violation by the South Africa of the international law, as confirmed by the General Assembly, the General Assembly decided to deprive it of the right to vote for 1 year. Basically, there was a resolution that said, until South Africa, changes its policy and dismantles apartheid, it will not have the right to vote in the General Assembly. And that was approved by the General Assembly. And you don't need the Security Council approval for that. So that's the way that exists. And I don't know why the Ukrainian, international experts. I mean, experts are flagging that it's not my invention. I mean, it is known. There were a number of articles to that effect in the Ukrainian press, and it was debated maybe a year ago, and very extensively on the Ukrainian TV. My friends, whom I know very well for many years, spoke there with proposing this solution, and it seemed to be of interest. But the formal path that was chosen by the Ukrainian government is to pursue the theory that Russian Federation has never been elected to the Security Council, because it just inherited this place from the Soviet Union without consent of other republics and now independent member states that constituted the former Soviet Union. So that's the theory that they are pushing, but it's to me, I see that it's not going to work at all. I mean, because that would mean that every decision taken by the General Assembly since 1991 would need to be deemed illegal, null and void, because it was taken with the participation of a party that had no right to be a party. You see the legal logic of that. So no one will do this on the UN. I mean, no one will nullify the decisions that were taken for 30 years. And it's an issue that happened 30 years ago. just not realistic to pursue this line of reasoning. It's much more realistic to pursue the other line of reasoning, quoting the precedent of the South Africa, saying that's how it was done. And by the way, it was the right to vote was taken for 1 year, and then in 1 year it was extended to another year, and then to another year, and that was happening until the end of apartheid. So that's the way, without a right to vote in the General Assembly, Russian diplomacy will not, they will still be a member of the United Nations on paper, but without a right to vote, they will be powerless, I believe. So that's the line of reasoning that I think is still to be understood properly by those who are responsible for the foreign policy in Kiev.
This is from one of the students in Ukraine. Thank you very much for this webinar. It has been an illuminating experience. What I would like to know is what key skills are crucial for managing international conferences based on all of your UN experience?
Oh, that opens a whole, type of other discussions, but international conferences include what's happening, the kind of the meetings of the main bodies of the United Nations that are taking place in New York, Geneva, Vienna, Nairobi, and everywhere, as part of the routine work of the United Nations. For instance, General Assembly is also a conference, right? So to make sure that the General Assembly works properly, that it has, works properly is enough, I think. The UN has a full division which comprises 3 branches. Approximately 150 people work in the Secretariat in New York just to ensure the proper functioning of the General Assembly, to ensure that every committee has a secretary, that the secretary is properly educated, briefed, knows their functions, what they can, what they cannot do, can run the committees, that they have support staff, that all documents are being published in all 6 official languages as required by the charter, the rules of procedure in all 6 official languages, how many, 30 days at least before a corresponding meeting, and so on and so forth. So skills that you need management skills. You need deep knowledge of the conference management in international organizations, which is very different from what is happening in the private sector, or even at the national level in the governments. Skills, languages, management skills, IT skills, that's what will bring you to the UN.
Some of our interns and students want to be working with the United Nations, and they are very impressed by what the United Nations is capable of doing. And so you're answering the question, it just helps them determine what area and what branch they really want to go. So thank you very, very much for your excellent presentation. It is certainly very particularly pertinent at this time. We wish you health, continued interest in what you're doing, and a lot of success in your future. Thank you very much.
Thank you very much, and I wish you all the best in your very noble and useful endeavor. Be healthy, and I wish all the best to all the listeners and participants today.
Thank you very much. Bye-bye.
Bye-bye.